Digital personhood and legal recognition, Korea's debate over avatar identity rights. The evolution of artificial intelligence and immersive technologies has prompted a re-evaluation of legal concepts, especially concerning digital personhood. In South Korea, the convergence of avatars, AI-generated agents, and metaverse environments has driven a national debate on whether digital entities can or should possess legal rights. This paper examines legislative proposals, judicial decisions, and stakeholder positions to assess the trajectory of avatar identity rights and the broader question of virtual personhood under South Korean law. South Korea has yet to enact comprehensive legislation recognizing digital personhood. Nonetheless, government initiatives indicate increasing engagement with the issue. The Ministry of Science and ICT has published white papers proposing frameworks for defining rights and liabilities related to AI entities, signaling a recognition that these technologies challenge traditional legal boundaries. Discussions in the National Assembly have acknowledged the potential need for new categories of personhood to accommodate non-human agents. Although no legislation has yet been passed, proposed regulatory updates aim to protect user data in interactions involving digital avatars. The Personal Information Protection Commission, in particular, has advocated for enhanced data protection protocols and platform accountability. Parallel to these developments, South Korean legal scholars have debated whether digital entities warrant recognition within the existing civil law framework. Some propose a functionalist approach, recognizing personhood where avatars fulfill roles analogous to human actors, while others warn against diluting the concept of personhood or introducing ambiguous legal responsibilities. Judicial developments have provided the most concrete advancements in the recognition of digital personas. In 2025, the Plave libel case marked a pivotal shift. The court ruled that defamatory comments made against the avatars of the virtual K-pop group, Plave, were legally actionable, equating harm to the avatar with harm to the human performer. This decision set a precedent in treating digital representations as extensions of individual identity. In a related case, the court upheld criminal liability for insults directed at virtual avatars, reinforcing that digital personas linked to identifiable humans are entitled to protection against verbal abuse. These rulings reflected a broader legal shift in which courts began acknowledging that avatars can embody aspects of human dignity. Other legal areas are evolving similarly. In 2025, South Korea's Ministry of Culture, Sports, and Tourism clarified that AI-generated content lacking human authorship is ineligible for copyright. This reinforced the human-centered basis of creative legal protections. A prior case involving the chatbot Eruda established that AI developers could be held liable under data protection laws for mismanagement of personal information. Together, these rulings delineate the boundaries of responsibility and rights in AI-mediated environments. The traditional legal conception of personhood in Korea draws from civil law traditions, recognizing two main categories: natural persons, individual humans, and juridical persons, entities like corporations. While digital entities fall outside these categories, legal theorists have begun to question whether a new classification is needed. Some argue that digital agents capable of acting autonomously or participating in social interactions deserve recognition commensurate with their functions. Others emphasize the necessity of human oversight, suggesting that creators or operators, not the digital agents themselves, should bear legal responsibility. Ethical concerns also persist, with scholars warning that granting legal personhood to AI may lead to unintended consequences or moral confusion. The court's interpretation in the Plave case, however, suggests an emerging compromise, acknowledging avatars not as independent persons, but as symbolic extensions of human identity, warranting protection where their representation causes real-world harm. South Korea's legal discussions are influenced by international models. The European Union's AI Act, which adopts a risk-based framework and explores the idea of electronic personhood, has shaped South Korea's AI Basic Act. However, Korea's version is more flexible, emphasizing innovation and post-market oversight. Japan's focus on ethical guidelines and maintaining human control over AI has also inspired Korean regulators, particularly in avoiding direct personhood recognition. South Korea's approach blends regulatory oversight with technological promotion, distinguishing it from more rigid international counterparts. Ethical principles are central to Korea's AI policy, which mandates respect for human dignity and emphasizes social trust in AI deployment. Rather than granting personhood outright, Korea's strategy relies on contextual protection of rights and responsibilities. A wide array of stakeholders contribute to this debate. The Ministry of Science and ICT and the National Artificial Intelligence Committee play leading roles in shaping AI policy, promoting ethical innovation while monitoring risks. Civil rights groups, such as the Korean Progressive Network Jinbonet, advocate for stronger safeguards in digital interactions, raising concerns about surveillance and discrimination. Leading AI developers, including Naver and LG AI Research, support regulatory clarity that fosters innovation while preserving public trust. The K-Humanoid Alliance, launched in 2025, represents a coalition of tech firms and public institutions pushing for the recognition of AI capabilities in industry. Legal professionals and academics continue to explore how these evolving technologies intersect with established doctrines, suggesting cautious but proactive legal reforms. The attribution of liability in AI-mediated interactions is also undergoing refinement. South Korea has criminalized the production, possession, and distribution of non-consensual deepfake content, especially involving sexual exploitation. Individual offenders are held primarily responsible, but platforms can also be penalized for failing to remove harmful content, or cooperate with investigations. In cases of chatbot fraud and AI-generated data misuse, developers may be sanctioned under the Personal Information Protection Act, while proposed amendments seek to extend liability to AI service providers. Although metaverse-specific laws remain under development, existing provisions on defamation and harassment apply to misconduct within virtual spaces. The forthcoming AI Basic Act includes guidelines for high-impact AI that may influence future rules on avatar-related harm. Public and media discourse has increasingly focused on the implications of avatar rights. The Playbible ruling drew widespread commentary, with many applauding the court's recognition of virtual identity as legally significant. Critics voiced concern over the scope of such protections, questioning how courts might navigate future cases involving satire, parody, or anonymous avatars. In response to growing use of the metaverse, the Ministry of Science and ICT issued ethical guidelines in 2022 addressing safety and identity protection, particularly for minors. South Korea's 2023 Digital Bill of Rights seeks to establish universal digital norms, though it stops short of endorsing full legal recognition for digital avatars. Cultural factors, including a tech-savvy youth population and high digital connectivity, have made issues of virtual identity particularly salient in Korean society. The expansion of metaverse platforms like Zip2 has intensified this legal discourse. Zip2's global user base and youth appeal have made it a focal point in discussions about digital identity, especially following the Plave case. Platform operators such as Naver Z have responded by forming safety advisory councils and joining international initiatives against online abuse. Academic research from institutions like Seoul National University and KAIST highlights how avatars serve as tools for identity experimentation, yet remain embedded in real-world cultural norms. This underscores the legal challenge of reconciling digital autonomy with real-world accountability. Chronologically, South Korea's legal trajectory began with the 2010 Constitutional Court ruling striking down mandatory online real name registration, which reinforced digital anonymity. By 2018, the launch of Zip2 marked a turning point in avatar-mediated interaction. The 2020 Nth Room case underscored the need for stronger digital protections. From 2021 onward, Initiatives like Metaverse Seoul and the Metaverse Ethical Principles began formalizing regulatory approaches. Legislative proposals in 2023, and academic contributions in 2024 laid the groundwork for the decisive 2025 court ruling that granted avatars defamation protection. Looking ahead, several future scenarios are plausible. In a best-case outcome, South Korea may codify digital personhood through comprehensive legislation, clearly defining rights, responsibilities and safeguards for digital entities linked to humans. A worst-case scenario involves legal stagnation, where lack of clarity leads to inconsistent judicial outcomes and diminished public trust in digital platforms. The most likely scenario is incremental integration, updating existing laws to cover digital identities, implementing ethical standards, and coordinating with industry stakeholders to ensure balanced protections. This middle path would allow legal recognition to evolve alongside technological change without rushing into radical reforms. In conclusion, South Korea stands at a critical juncture in its treatment of digital personhood. While full legal personhood for AI-generated agents remains unlikely in the near term, the increasing recognition of avatars as legal extensions of human identity marks a profound shift in the country's jurisprudence. Through a combination of court rulings, policy experimentation, academic engagement, and international benchmarking, South Korea is gradually shaping a legal framework capable of addressing the unique challenges posed by digital and AI-mediated interactions. As this framework matures, it will determine not only the status of virtual beings in law but also the ethical boundaries of identity and responsibility in the digital age.